What you're looking at here is my work in the High Court concerning the broad protection of personal liberty. So I started two cases in 2024, and their record numbers are 2024 6645P and 2024 6852P. The Constitution of Ireland provides the people of Ireland, the citizens of Ireland, with a broad protection of their personal liberty, which is not tied to their physical movement. And our Constitution sequentially protects it. It guarantees that all citizens shall be treated equally before the law, and it guarantees that the state, in its laws, will respect and, as far as practical, by its laws, to defend and vindicate the personal rights of the citizen. And that includes the vindication of life, person, good name, and property rights of every citizen. So every citizen in Ireland is born with the inherent possession of personal liberty. It's a possession that has to be respected and protected by the state, and it has to be maintained through our fundamental sequential personal rights protections in Article 40 of the Constitution of Ireland. Now, the High Court has recognised it as a broad protection under 2025 IEHC 163. It has recently, in July, brought it out from habeas corpus. So it was used only up until I started exercising it as a broad protection, as only a right that existed if somebody was unlawfully detained. And I said, no, personal liberty is our right to expect equal treatment before the law, and our right to expect the state to guarantee and protect those our personal rights. I'm holding state employees accountable to the court. And not only am I holding them accountable, I'm bringing their legal representation to the higher courts, which is the Court of Appeal. I'm asking the Court of Appeal this Friday to release the DAR, 2 days of hearing in the High Court between the 3rd and the 4th of June, which I vigorously argued the sequential protection of our fundamental rights. Unfortunately, the court services, the Chief State Solicitor acting out under the Attorney General and the government, and members of An Garda Síochána, as well as the Commissioner of An Garda Síochána, argued for a narrow version of our personal liberty, contrary to what the Constitution of Ireland provides. So these are state bodies working for the executive. The executive does not exist in real life. The executive does not have constitutional rights. And when it comes to personal liberty, only the citizen has constitutional rights. So I'm going to keep you updated with this work, because this work is going to be a work that you're going to see develop day by day, week by week, month by month. I'm going to be out in public exercising this case law. This case law has pinned personal liberty now onto physical movement outside of a prison cell. Now, that's not broad enough, because personal liberty is our right to basically live in peace once we're not depriving anyone else of that right. It's our right not to be interfered with by our government, okay? It's our right to expect that our personal rights will be protected and vindicated by the state. So I'm going to bring this out, and I'm going to show how this judgment is contradictory to the spirit and intent of the Constitution of Ireland. But to do that, I have to physically put myself into situations where I can assert that my personal liberty has been deprived from me. Now, I don't want my personal liberty to be deprived, but I have to show the High Court how this judgment by putting personal liberty onto our physical movement is restricting it in a way which is opposite to what the Constitution of Ireland provides to its citizens. And thank God we have a constitution with these powerful words written in it. Because if it wasn't for this constitution that we have, we wouldn't have personal liberty at all. And God knows where we would be being left at the hands of individuals employed by our state, trying to undermine not just our rights, but their own rights as well. These people that work for the state have families and more than likely have children. And what they're doing, what they're being paid to do, they're not being paid to undermine our fundamental rights. They're being paid to do a job. They're not being paid to go into a high court and use the money generated by the taxpayers to pay high-class barristers and the Chief State Solicitor's office to go into our High Court and restrict personal liberty from the citizen. It cannot be stood for. These individuals are undermining and subverting our constitutional rights, and they have to be held accountable in a court of law. And that's why I'm in the High Court creating judgments with judges to protect our personal liberty from this blatant overreach by the executive. And we can only do it on the public record, and I'm going to share all these records with you so you can travel with this legislative and constitutional journey.